Hello. In this video, we will examine gaming laws and regulations in India. Gambling has been in existence since time immemorial. From the Indus Valley civilization to the Mesopotamian period, there have been ample pieces of evidence of the existence of the game. It is seen as a game of skill by some and a game of chance by others. It involves consideration, risks, prizes, and is in itself a game of probability. On an international level, there is no consensus among countries on how to regulate it. Even on a national level, most of the countries have different laws in different states. Thus, the regulation of gambling on a general level is difficult. The main objective of regulating games of chance across various countries is to control games of chance, with a particular emphasis on counteracting gambling addiction, protecting consumers, and preventing unlawfulness and crime. The majority of gaming operations in India are strictly regulated. There are a few exceptions to this rule, including lotteries as well as horse racing. In India, gambling is a state matter, hence only the state legislatures have the authority to define and regulate such operations for their own states. The primary legislation governing gaming in India is the Public Gambling Act of 1867, usually referred to as the Gambling Act. Nevertheless, as the state governments have been given the regulating authority to create gaming laws specific to their own states under the Indian Constitution, it is actually the state that creates these regulations in accordance with its own needs. The Gaming Act is the primary law that certain Indian states have adopted, and other governments have created or passed their own legislation to control and oversee gambling on their own soil. Since the majority of gambling laws that have been passed were passed before internet gambling and betting became common, the laws generally apply to gambling activities that take place offline. Many Indian governments have been enforcing the gaming legislation since the days of British administration, making all types of gambling and betting illegal in each state. The only states that permitted gaming and betting were Goa and Sikkim, according to the rules set out by each of these governments. One notable instance that leads some to conclude that gambling was used in earlier times is the mention of dice games in the Mahabharata. These were historically seen as components of human development. Gambling legislation and licensure are comparatively recent developments. Prior to it, gambling was an unrestricted form of income and enjoyment. Gambling is referenced in Atharva Vedic songs, Rig Vedic hymns, and Manu Smriti lyrics. These verses depict gaming as a source of devastation and a financial strain for the traders' clan. Many archaeological studies have shown that there was gambling among some of the primitive man. The first gambling chip was created in Rome, another well-known location for gaming. Gambling practices and the regulations governing them have changed significantly. People may easily gamble and place bets today using their smartphones or computers. Gambling has advanced greatly and is continually evolving, from centuries-old forms of amusement to internet gaming. States are already passing unique legislation to control internet gambling. The Indian Constitution gives individual states the authority to enact laws determining whether or not gambling regulations are allowed. If the Parliament does not use its authority under Articles 249 or 250, it is implied that only state governments may pass legislation governing betting and gaming. The state governments are also given the authority to pass laws governing the imposition of taxes on gaming and betting under Entry 62. The control or ban of forms of gambling often sparks fierce debate. Numerous proponents of gambling and businesses that profit from it are against the limits that federal and state laws have placed on these activities. These are regarded as going against the spirit of Article 19(1)(g), or the freedom to engage in any profession or business. In a famous case from 1957 called State of Bombay v. RMD, Chamarbawala, the legitimacy of prize contests was at issue. The petitioners said that prize contests and lotteries are eligible to safeguarding under Article 301 and claimed that the Prize Competitions Act, 1955, violates the basic right contained in Article 19(1)(g) of the Indian Constitution. The Public Gambling Act of 1867 is a fusion of the Irish Betting Act of 1853 and the United Kingdom's Gaming Act of 1845. The term common gamehouse is defined under Section 1 of the Public Gaming Act of 1867, and the Act specifies the penalty for the occupant or owner of the gaming house. This clause specifies what constitutes unlawful gaming. Games including playing cards, dice, tables, or other gaming equipment are illegal when they are stored or used with the intention of making money. It specifies the sanctions for in-public gambling. Additionally, anyone in control of gambling establishments faces penalties under this act. The punishments are as follows. 1. Penalty or cost of owning a gambling house. A fine of up to 200 rupees, or a term of imprisonment of no more than 3 months, whichever comes first, may be imposed on the owner or manager of a gambling establishment. The following groups of people are penalized under Section 3. Anyone who owns or occupies a gambling establishment is responsible for its maintenance or management, or makes investments for such uses. 2. Penalty for being found inside a gaming house. If someone is discovered at a gambling establishment, they might face up to a month in jail or a fine of up to Rs 100, according to Section 4. In gaming establishments, it is not permissible to use dice, cards, counters, money, or other game tools. 3. Penalty for giving false personal information. A violation of Section 7 of the Public Gambling Act occurs when a person is discovered within a casino and, upon being detained by a police officer, refuses to give personal information or gives false information. A fine of Rs 500 or up to 1 month in jail is the maximum penalty for this offense. 4. Penalty for gambling in public. According to Section 13, the following offenses are punishable by a fine of up to Rs 50 or up to 1 month in jail. For using dice, playing cards, or engaging in any activity that isn't a game of skill on a public street for the purpose of profit or value, for forcing animals or birds to struggle in front of the public, for gambling on the fights, or helping others place bets. Since gaming and betting are covered by state lists, state legislators can create laws that address them. Therefore, it is up to the state authorities whether or not to incorporate the requirements of this act into their state statutes. The Lotteries Regulation Act, 1998. A drawing of lots in which prizes are given to the victors among those purchasing a chance is how a lottery is defined. The act gives the states the authority to regulate lottery operations, from running them under their control to collecting money for the public coffers. The hereunder are some of the key elements of this act. It describes lotteries as a plan in which the participants who take part receive rewards by lot or luck. The legitimacy of the lottery tickets must be reflected in the writing. The lottery activities should be run by the state legislature, and money earned from them should go into the state's general fund. There shouldn't be more than 6 bumper draws every year. The selling of subscriptions for lottery held in any other state may be prohibited by the state legislature of one state. When an agent, marketer, or dealer violates the terms of this act, they are committing a crime that is punishable by a fine but not by posting bail. The penalty is strict incarceration for a time that may last up to 2 years, a penalty or both. Prize Competitions Act, 1955. The Prize Contests Act specifies the requirements for organizing prize competitions. In accordance with Article 252(1) of the 1950 Indian Constitution, this act was passed. The maximum number of entries is 2,000, and Section 4 of the Act states that the total prize money that is allowed is up to Rs 1,000 every month. The majority of states have distinct laws that address this. As a result, this act is no longer necessary. The Foreign Exchange Management Act, 1999. Foreign direct investments are not permitted for the operation of lotteries in India under the Foreign Exchange Management Act. Under the Foreign Exchange Regulation Act, the Foreign Exchange Management, Current Account Transactions, Rules 2000 were passed, and they place restrictions on transactions involving outside gambling. Results available on foreign exchange are not permitted while sending lottery prizes, lottery tickets, etc. As a result, gambling is not allowed in other nations. While some states have accepted the Public Gambling Act of 1867, others have created their own laws based on its structure. Many states, including Maharashtra, Gujarat, Telangana, Nagaland, and others, have passed their own unique gaming legislation. Game of chance vis-a-vis game of skill. A game of skill is based on the skills and expertise acquired and honed by the individual. A game of skill offers participants the flexibility to test their athletic prowess. They are encouraged to become acclimated to a particular set of instructions while searching for methods to develop and use new techniques with routine training. Competent players typically recognize how to apply tactics to their gaming in order to succeed. Generally speaking, a player's odds of succeeding in a game of skill are higher the more seasoned they are. Thus, consistent practice is necessary to succeed in a game of skill. A game of chance is primarily decided by an arbitrary element of any kind. Even when talent is used in games of chance, victory is still mostly determined by probability. While the majority of chance-based games rely on fate, other games, like poker, also require some amount of ability to win. Games of chance typically need less professional expertise, making them simpler to master. Undoubtedly, there are aspects of chance and components of skill in any game. The main conclusion that must be reached in order to establish if a game is a game of chance is that the factor of luck outweighs the portion of ability. Therefore, a game of chance is one where the result is decided by luck instead of ability. Any game of skill and a game of chance differ significantly from one another. The first distinction is who the aforementioned person is competing against. If the alleged player is competing against the establishment, they are playing a game of chance. On the contrary, it is considered to be a game of skill when the participant is up versus opposing competitors. Additionally, a game would be labeled as a game of skill if someone could conclusively show that it relies mostly on abilities like arithmetic, analytics, and strategy, with a tiny bit of randomness or chance. There have been several discussions between lawmakers and gamblers over the legality of games of chance in various parts of the world. Games of chance nearly always need some amount of ability to play, according to advocates of legal gambling. Thus, they ought not be viewed as prohibited. It's important to note that many academics have researched chance in relation to gambling and the way a player may change specific variables to increase their odds of winning, which many people view as a type of skill. However, lawmakers look at the adversary of the player to decide if a game is skill-based or random. Any game in which the player competes against the house is dependent on chance. However, the game is categorized as a skill-based game when the participant is competing against other players. A game employing fortunate numbers is not regarded as a skill-based game, but those that need strategy and cognitive skills, sets like arithmetic acumen, may be. Judicial overview. Numerous lawsuits have been brought by associations involved in gaming to designate these activities as games of skill so that they can acquire legal standing and never be considered unlawful. However, when the courts are asked challenging questions, a response to such queries is given along with an articulate justification of their view of that particular issue. The courts have occasionally carefully considered the relative weights of chance and skill for each game to find which one predominates, and if placing a wager in such games would constitute gambling. It has been ruled that the facts and conditions unique to each case should be weighed when determining whether a game is regarded to be one of skill or chance. The Honorable Supreme Court explained the distinction between the three-card game Rummy and Teen Patty, holding that while the aforementioned was a game of pure chance, the other needed a specific amount of skill because one had to remember the order in which the cards fell, and the accumulating of rummy necessitates significant skill in deciding which cards to retain and which ones to toss away. The Apex Court concluded that rummy qualifies as a game of skill since it is played more often. When the subject of horse racing came up, the Honorable Supreme Court ruled that it should not be classified as gambling or gaming, but rather as a game of mere skill, where mere talent refers to a significant level or preponderance of competence. This was construed in this way on the assumption that horse racing is determined by the innate potential of the horse, the expertise and aptitude of the rider, the shape and general stamina of the horse, the load it can hold, and the range of the race, all fair factual information that can be evaluated or researched by racegoers. As a consequence, it was decided that talents rather than random chance were responsible for the forecast of the race's outcome. In relation to the game of poker, the Honorable High Court of Karnataka noted that it is a game of skill and that, when played in compliance with the rules established by the state, no license is needed to perform a game of skill, which would also include poker, on property intended for leisure activities. It was further reiterated that poker is not considered a form of gambling in the West Bengal Gambling and Prize Competitions Act, and therefore law enforcement officials are not allowed to meddle with such games. The Gujarat High Court, however, held a different perspective. Poker has been deemed a game of chance by the Supreme Court in the wake of its ruling in the K. Satyanarayana case. The same court is still considering an appeal of this judgment, nevertheless. The debate over whether poker is a skill-based game or not continues to this day, and in many jurisdictions, playing poker online is seen as illegal. The game has even been altered by a number of service operators and internet resources to make it a more difficult game. To support this, several websites remove the element of chance from the game. As a result, the player's talents have become more important in deciding the game's victors. In order to determine the legality of any game, especially when played for real money, a determination of whether such game will contravene any applicable gambling legislations will need to be made.